Ladies and gentlemen, good afternoon. This afternoon, we are going to discuss our second topic in this program of certified human resource audit. And that is the legal and regulatory compliance. This is a very insightful topic because many organizations around the globe are struggling with legal and regulatory compliance. Some organizations have registered very high or big fines, penalties, and even lawsuits, which cumulatively have affected their operations, their reputation, as well as their strategies in terms of implementation. Even at the individual level, when you have a legal issue around your neck, it can become a very challenging issue because you'll spend a lot of time, energy, and money trying to fight it off. As HR managers, we have a responsibility of mitigating the risks associated with legal and regulatory compliance. Legal compliance relates to the laws of a country that govern the employment relationship. In a short while, we will be discussing these laws, particularly the labor laws, as set out by the National Assembly. These laws are not there to prevent anybody from functioning effectively, but they are there to guide the employee and employer relationships. And therefore, it is incumbent upon all HR managers and officers to have an understanding of the laws that govern the employment relationship. I am aware that there are some organizations that have legal officers, but that does not prevent a HR manager to understand the legal provisions in their dealings with employees. This will not only help HR managers to deal with legal issues, but also create an environment where employees are treated fairly and justly. On regulations, these are rules or guidelines that are set by one, government bodies or regulatory bodies, which I will briefly talk about, or secondly, international labor organizations such as ILO. These regulations must be complied with, but they originate from bodies mandated by law to develop them. Non-compliance may lead to sanctions and even prosecution. They provide guidelines as well as to what, where, and when HR managers should act so that they do not overstep the legal requirements. So having said that, I want us to look at the key themes that we shall discuss this afternoon. There are three of them. One is the legal framework, which we are going to review, albeit briefly. And this legal framework relates to the various laws that govern the employment relationship. For example, the Employment Act and what aspects of the Act should be complied with, because we are talking about compliance. Secondly, we will look at compliance mapping, where we are looking at various areas in the HR function and the legal framework governing each area. And then, if possible, in our HR audit, we are able to identify gaps where our policies, procedures, and systems are not complying with the legal framework. So we shall map or try to juxtapose HR functions against the various labor laws and then try to identify gaps. And after that, we shall see what action plans should be put in place in order to ensure compliance. This compliance mapping is very important for HR managers because it makes it easier for us to audit all the... Sarah? Okay. It is important for us to do the mapping because it helps us to audit the HR functions to ensure compliance. And the last theme is audit of disciplinary procedure. I know for a fact that disciplinary procedures come under the labor relations, or what you call employee relations in organizations, where we talk about various aspects, but for purposes of this presentation, disciplinary procedure comes out as one of the key aspects that many managers and organizations find it difficult to comply, or even if they do, this is an area with a lot of litigations. Why? Because again, it is because of a gap in the disciplinary procedures that lead to those litigations or lawsuits, penalties, and fines. So these are the three key areas we are going to discuss starting now. But first of all, the introduction. Introduction to legal and regulatory compliance. By definition, I've indicated there that legal compliance relates to adherence to the various labor laws, rules, and regulations. Adherence. That's another word for compliance. It is important to understand compliance because it is our responsibility to ensure that our practices, our policies, and our systems are aligned with the various labor laws. as well as regulations. So compliance is basically ensuring that our policies and practices adhere to the labor laws. And then what is the purpose of legal compliance? Quite a number of them, but I've condensed them to two. It protects employees and employers from legal risks affecting them. Allow me to mention a few of these legal risks so that as we think of compliance, we are mitigating them. One is penalties. That if we fail to comply or we violate the labor laws and regulations, we are likely to be penalized as a form of punishment. One of the punishments could be reinstatement of an employee who has been dismissed. Two, payment of the employees or relevant authorities for violating a labor law or regulation. Or three, being suspended. I believe all of us are aware of the transport industry, where the regulator, and that is the National Transport Authority, NTSA, suspended licenses for some companies for violating road regulations or traffic regulations. The same thing can happen to us if we violate labor laws, that we can be sanctioned. So that is one risk. Another risk is lawsuit, that employees or other organizations can sue our organization, or in some cases sue us individually for violating those labor laws. We all know, and perhaps have been through this process of lawsuits. These lawsuits are time wasting and they are costly. Costly in terms of legal fees and production of services where we spend a lot of time away from our offices. And that is why in many cases, organizations avoid the corridors of justice or the courts and opt for out of the court settlements. Because out of court, you negotiate outside the court and it is less expensive. Therefore, when we look at legal compliance, we are protecting the employees as well as the employers, who are ourselves, from those legal risks. What is the scope of legal and regulatory compliance? These are the areas that are covered. One is about contracts. We all know that any employees that we have must be given a contract. Whether they are independent contractors, permanent employees, or short-term employees, should be given contracts. And these contracts are binding according to the Employment Act. So one of the areas that is covered in legal compliance is contracts. Secondly is wages and benefits. Wages is used to generally involve salaries, though we know the place of wages in organizations, especially when it comes to the types of contracts. If a person is on permanent and pensionable contract or a fixed term contract, they are paid salaries because their pay comes at the end of every month. But for those on short-term contracts like casuals, they are paid either daily or weekly or at an agreed time, and you call that wages. These wages are regulated, and we know from the Employment Act, there are provisions on one, types of wages that can be paid, two, when the wages will be paid, three, where the wages will be paid. For example, if a person is not working in a social place like a bar, they should not be paid in a bar. So one of the regulations in wages is that a person should be paid at the places where they are working. So anything outside that becomes a violation and it can be costly to the employer. Benefits are any forms of rewards that employees get outside their salaries and wages. This could be medical benefits or retirement benefits. So in terms of compliance, there are certain benefits that are regulated. For example, retirement benefits. It is a requirement under the NSSF Act that employers who have more than 5 employees must register with NSSF and start contributing. And these benefits are due upon the retirement of the employee, either voluntary or upon attainment of the retirement age. Another area covered under legal compliance is diversity. And one of the labor laws that regulate this area is the Employment Act, where employees should not be discriminated against on account of their color, tribe, call it ethnicity, or training or religion. This is a protected area because we want to give equal opportunities to everybody. Nobody should be left out in nation building, especially in the public sector. When vacant positions arise, it is encouraged that even the disadvantaged communities or minority communities should be included in this election. We should reflect the diversity of Kenya, even in terms of our ethnic backgrounds. And then workplace health. This is very important because we want a healthy and a safe work environment. Why? Because a healthy workforce is a productive workforce. If our places are unhealthy, then there will be injuries and illnesses, which are costly in terms of time spent away from work and also compensation in cases of injury or even death. What is the purpose, the importance of legal compliance? I have indicated some of them. One is lawsuits where employees go to court or other organizations going to court on their behalf. Two, financial penalties where some fines could be imposed, and reputational damage. It's about the name of the organization, and organizations that are keen on their reputation will always ensure that they comply with all the labor, environmental, and other laws. What is the role of HR managers in this legal compliance audit? I will discuss this again in detail when the time comes in today's presentation. But basically, the role of a HR manager is to identify compliance gaps. These gaps are areas where our policies, our procedures, and systems are not compliant. And this may relate to recruitment and selection, training and development, performance management, or compensation and rewards. As I indicated, HR audit is about evaluating or reviewing policies, systems, processes, and procedures for purposes of ensuring compliance. If they are not compliant, then there is a legal compliance gap, which should be addressed immediately. Then lastly, what could be the outcome of legal compliance? It assists in developing an ethical, transparent, fair, and lawful workplace. Ethical refers to the moral standards that are agreed among community members, an organization, or a profession. I will be indicating some of the ethical issues like transparency or professionalism in the HR practice. That when we comply with the laws, because we know the law has the overtones of moral authority, which is an ethical standard. All ethical behaviors arise from the law. So we need to promote ethical work environment. Secondly is transparency, that we need to be open. The law promotes that transparency, that we should not be hiding anything from our employees, especially on matters that they should know or how they should be treated. There's nothing to hide from them. We should apply and interpret the law as it is. Although in some cases we have challenges of interpretation, but to implement the law as it is, any exception. So transparency is one of the outcomes of legal compliance because employees have certain rights which they should know. They also have obligations which they should know or understand. On fairness, legal provisions ensure that employees are treated fairly. Fair treatment in recruitment, fair treatment in training, fair treatment in compensation, as well as fair treatment in disciplinary process. The law provides standards for fair treatment, and those are the standards that we should apply when we are performing our functions. And then it builds a lawful workplace where all processes, all systems, and all policies are guided by law. We may be aware that without the law, the rule of the jungle takes over, or the jungle or government ends where rules end, or where there are no rules. And because of that, without rules, our environment will be like the jungle. What happens in the jungle? There is no law. Other animals eat others. Others trample on them. And others infringe on other people's boundaries. So to be on the right track and to avoid the rule of the jungle, all laws must apply. We now work in the comfort or with the comfort that everybody, irrespective of their location in organizations or their position, should be treated lawfully. Any unlawful practice should be reported or should be identified in the audit, and then corrective measures be taken. What corrective measures can we take if there are gaps? Basically, one, ensuring compliance. And therefore, we review our policies, identify those gaps, and implement them as required by law. So those are the key aspects that relate to legal and regulatory compliance. Our first heading under this topic, or subheading under this topic, is legal framework. Legal framework relates to the 5 key aspects that I've mentioned there. One, the laws. There are various laws that govern employment relationship, starting with the Constitution. The Constitution is the supreme law of the land, and all other labor laws are derived from the Constitution. Secondly, we have the Acts of Parliament, which regulate various sectors and industries in a country. For us in HR, the Acts of Parliament that regulate the employment relationship are the labor laws. We shall be looking at 6 or 7 of the labor laws that govern the employment relationship. These are not options, but requirements. Requirements that must be obeyed by all organizations and all managers without exception. Then, speaking of regulations, these are rules that govern specific industries or sectors. Some of us are working in manufacturing, others in health sector, others in educational sector, and other sectors. So there are quite a number of regulations or laws that are developed by the respective regulatory bodies. Other regulatory bodies or regulations cut across all organizations. For example, National Environmental Management Authority regulations, which talk about health and safety of people as well as environmental protection. We must protect our environment. Coming down to organizations, there are policies. Policies are guidelines that answer 6 WH questions. WH questions. What is to be done? Why it should be done? When it should be done? Who should do it? And how it should be done. So policies guide us on what, where, when, how, and who with respect to the various functions. For example, recruitment, what should be done, why, when, who, where, and how. So if you answer those 6 questions, you will have provided a guideline on recruitment and selection. The same applies to training. We have training policies. Answering the question, what should be done before training? Why it should be done? By who? When? Where? And how? So the question somebody can ask in training, Mwalimu, where does how come in training? How is the methodology of doing training? So you can do on-the-job training or off-the-job training methods. So the how related to on-the-job training is mentorship. How do we train? Through mentorship or through coaching or through apprenticeship. So those methods answer the question, how? So if it's compensation, how should we compensate our employees? So the how here is either in cash or through EFT, that is electronic funds transfer, or a check. So that answers the question, how? And the policies help us to understand our roles as HR managers and what is expected of us. Next is the guideline. These are procedures and processes that arise from policies. For example, there is a guideline on disciplinary policy. And the guideline is what managers and or employees should do when it comes to the disciplinary process. So these guidelines will help to conduct disciplinary procedure efficiently and effectively by looking at the nature of the offense and the procedures to be followed. And lastly, institutional arrangements. These are systems and structures within our organizations that help us to implement those guidelines, policies, regulations, and laws. For example, what are the institutional arrangements related to recruitment and selection, particularly on diversity? If the law is on diversity, we must have a policy on diversity. So what could be the institutional arrangement on diversity? One of these arrangements could be ensuring the 2/3 gender rule in every team that we form. For example, in recruitment and the selection panel, we should have a gender balance as a way of demonstrating our respect to diversity in recruitment and selection. Because a candidate can present himself or herself in the panel only to find women only or men only panel. And some candidates may feel disadvantaged because one of their own is not on the panel. Other institutional arrangements in other areas like training is to ensure that everybody has an equal chance of being trained. And that means that we develop a training program where everybody has an opportunity to be trained for that year. So with that training program, we know who is going for which training, when, where, and how. Basically, all the above 5 key elements of the legal framework govern how activities are conducted within a country, a sector, or organization. Ours is an organization because we work in organizations. So we focus on activities and how they are conducted with respect to the various laws, regulations, policies, and guidelines. Having said that, I want us to move to the scope of this legal framework and compliance. What does it cover? Quite a number of aspects which are contained in our various policies. One is employment laws. Most of our employment laws relate to contracts, terms of employment, and equal opportunity employment. Particularly the Employment Act talks about all this, starting with contracts. So when we are auditing activities in our organizations, because we looked at the last sentence there, all the laws, regulations govern how activities are conducted. So when we are drafting the contracts and terms of employment, which are activities, they must be in compliance with the labor laws or employment laws. As we shall mention, there are quite a number of them that we shall mention, so that we are clear on which of them we are referring to. Terms of employment relate to the working conditions and the payment that is given to employees, as well as the requirements for somebody to do that job. And these terms of employment become binding because they hold the expectations of both the employer and the employees. From the employee side, they expect to be paid according to the contract. They expect to be provided, for example, PPEs, personal protective equipment. They expect a conducive work environment. And in return, the employers expect the employees, one, to obey rules and regulations as well as policies. Two, attend work on a regular basis. And three, perform to expected standards. So in different languages and forms, these become the terms of employment. And if the employees agree with those terms, then they can sign the contract and agree to abide by the terms of those contracts. Previously, I've mentioned equal opportunities, that all of us, irrespective of our background, should be given an opportunity to serve, both in public and private organizations. And in equal opportunities, there are laws governing that, especially the Employment Act, that there should be no discrimination against an employee. And that is captured in our last bullet, if you look at our screen. The second area covered under compliance is wages and benefits. Several aspects are covered under this area. The minimum wage. The Employment Act sets the minimum wage, but there is no maximum wage. Why minimum wage? It is meant precisely to protect employees from exploitation. And exploitation is a form of forced labor, where employees are not paid or paid minimal wages just for survival. So to avoid modern forms of slavery and exploitation, the Employment Act sets out the minimum wage. You can pay as much as you wish, depending on whether you can afford or not, and also the type of employees that you have. But anything below the minimum wage is a violation of a legal requirement, which may lead to a lawsuit or even a penalty. You can imagine that you have been paying your employees below the allowed minimum for a period of like 10 years. And when employees go to court, there are penalties. You may have to pay for all the 10 years that you have not paid your employees according to the minimum wage requirement. Overtime. Some organizations have a 24-hour working system or hour, 24 hours. And if not, sometimes organizations want to cover or serve their clients more by extending the time employees are working. So anytime an employee works beyond the 8-hour requirement by the Employment Act is treated as overtime. If your organization does not work or do work on Saturdays, then an employee working on Saturday should be paid overtime. And that also spreads into the public holidays. By law, a public holiday is a resting day. And anybody working on a public holiday except the armed forces should be paid overtime. Armed forces are exempt from holidays. And then another area under the wages and benefits is retirement benefits, where you may have a private retirement plan or the one that we know, which is public retirement plan. These benefits help to motivate employees, and in some cases, there are benefits that employees get even after retirement. I know of some organizations which allow their retirees to continue having their medical cover, which to me is a good practice, and if it were possible, should be practiced by everybody. Another area under legal compliance is health and safety, where we should ensure that our workplace is healthy and safe. Healthy because we want to avoid illnesses, and safe because we want to avoid accidents. So a healthy environment is one that ensures that employees don't fall sick. And there are quite a number of provisions under the Occupational Safety and Health Act. Water to their employees for drinking. This water should be healthy and safe to drink, meaning that this water should be tested for any bacteria or viruses to protect their employees. Otherwise, we run the risk of having a pandemic in an organization, and the organization may have to be closed because the Directorate of Safety and Health, DOSH, might come down hard on you if you are not compliant with some of these health issues. On safety, this is protection of our employees from injuries or harm. Our workplaces must be safe. Safe in the sense that there are no accidents. We should minimize or eliminate accidents from our organizations by putting in place all measures that protect their employees. So what are the safety standards that should be in place? One, signs. These warning signs attract the attention of employees and passers-by to unsafe environments, or what you may commonly call a hazard, a safety hazard. For example, safety floors. These floors must have signages so that people are able to see that the floors are slippery, either because of the tiling or because of water or cleaning that is in progress. On another aspect of safety is provision of protective gear or equipment, such as helmets, gloves, overalls, and gumboots. They protect employees from safety. When we are doing an audit of this, we can do observations, for example, and see whether all employees have been provided with safety or protective equipment, especially those that are working in factories or using machines of any nature. For front office, rarely do we find people wearing PPEs unless it is extremely necessary. In construction sites, people must wear their protective gear like helmets because of falling objects. So this area is very important because it ensures that our employees are not sick and that they do not get injured. And these two are very expensive in an organization. Another area that is regulated is labor relations. That is the relationship between the employer and the employee. If you read the Labor Institutions Act, this is where all these four components or three components are discussed. The Labor Institutions Act. One of the institutions in this act is the trade unions, and it provides for registration of trade unions, functions of trade unions, membership of trade unions, and the role of trade unions. We all know that those of us that have unionized employees, the trade unions negotiate on their behalf through their representatives. So under the Labor Institutions Act, we have trade unions which come in strongly when there are negotiations between employees and employers. Two, collective bargaining. This is an agreement between the union and the management. Under this act, the agreement must be registered with the Labor Relations Court for it to be binding. If the agreement is not registered, then it is not binding. And that is an area that is covered under labor relations. And I'll be talking about the Labor Institutions Act. And then employee representation. Even at the national level, based on the Constitution, employees have a right of representation, either directly or indirectly through their representatives. Directly because employees participate in activities in organizations directly. And they have a right to question, have a right to information related to aspects that affect them. And then they can exercise this right indirectly through their representatives. The representatives of the employee is the union officials. At the organizational level, these are shop stewards. So when an issue arises touching on employee-employer relations, then all the employees must be represented, either directly or indirectly. Another area of compliance which is covered in this framework is data privacy. I have indicated there as an example of Data Protection Act 2019. This Data Protection Act provides for certain regulations which must be complied with by both the employer and the employee. That there are certain data that are private to an individual. For example, a telephone number. It is not confidential, but private. Private because they touch on an individual. Confidentiality meaning that information that should not be known by others, it is protected. So we have a right to privacy. Our telephone numbers are private numbers. So nobody should share a telephone number with a third party unless with the consent of that member. Privacy also talks about frisking an employee at the point of entry or exit. We frisk our employees for purposes of security or preventing theft. The security officers can frisk the employees as they enter or leave the organization, but they should not infringe on their privacy. There are certain parts that should not be touched. That is their private parts. Or nobody should look at the contents of their telephones unless with the permission of a court of law. Those are private matters. Other matters which are private include marriage or marital status. That is private. The number of children that somebody has is private. How about confidentiality? This is information that should not be shared with others. And which confidential information that we should protect? One is the salaries of employees. It's confidential. Nobody else should know except the employee himself, or if they volunteer, they can volunteer. However, in many organizations, there is a policy on the payment of employees, particularly with sharing of information about salaries. Some organizations do not encourage discussions on salaries because they are likely to cause dissatisfaction or complaints. So matters to do with salary is confidential. 2, health status of an employee, health. Whether somebody is sick or not is confidential to them. So such information should not be given to other third parties. Other confidential information include organizational rights or copyrights, as it were, or formulas, or company secrets. These are confidential information. And that is why we are required, even in our contracts, not to volunteer confidential information to anyone outside the organization. So matters touching on the formulas, on the copyrights should remain in the organization. They are protected. A breach of privacy and confidentiality means that action can be taken either by the individual employees or organization or by the Office of the Data Protection Commission, ODPC. Lastly, our legal compliance touches on discrimination or anti-discrimination. That nobody should be treated unfairly, regardless of their background, such as gender, age, or disability. We all have a right to work in organizations irrespective of our gender. The fact that somebody is a woman or a man does not mean that they can't work. Even when we think of the gender roles, traditionally, women were supposed to be in homes taking care of children and their husbands. And therefore, they did not have an opportunity to work in public and private sector organizations. but this has changed over time. We have women employees working, and some of them even work better than men. So gender issues should not be a source of discrimination whatsoever when it comes to recruitment, to training, or to compensation. On matters age, it is a requirement by the Employment Act that we should not employ minors. That is not discrimination. Because the moment we employ young people below the age of 18, that amounts to child labor, which is against the Employment Act and against the ILO Convention on Employment of Children. And then disability. In our workforce, people have disabilities, either problems with their eyesight, problems with the hearing, problems with the walking, or even speaking. Such people should not be discriminated against. They should be given equal opportunities, because the fact that a person cannot see does not mean that they can't think or they cannot be innovative. Some of these fairly challenged people or physically challenged people have very good ideas that they can contribute, including people with autism. Some of them are very sharp. And speaking of autism, we should develop a policy in our organizations to ensure inclusivity of people with mental challenges, not madness, but mental challenges, such as autism or bipolar. Which policy is this? We call it neurodiversity, a policy that will take care of bipolar and autistic employees, among other mental challenges. So those are the areas that are covered under legal compliance. Before we take a little break, let us talk about sources of legal framework. Meaning that where do we get the laws that regulate the employment relationship? Where do we get them from? One is national legislation, and these are labor laws that are enacted by Parliament and therefore are used to regulate the employment relationship. They form the legal framework. The various types of laws in the form of acts of Parliament, like the Labor Relations Act, the Employment Act, Work Injuries Benefits Act, as well as OSHA. Those are national legislations. Number two, regulatory authorities. I have mentioned one of the regulatory authorities this afternoon, and that is NEMA, National Environment Management Authority. That as organizations, we produce waste. This waste must be disposed of properly. If you are in a hospital, you produce waste such as cotton, such as needles, which have been used and can be dangerous to the people around the hospital. As a requirement, you are supposed to have an incinerator to burn those health waste or medical waste. Otherwise, it will be a crisis when people inhale the smoke or are exposed to needles that have been used. So it is a requirement that this waste must be disposed properly and in designated places. Even those of us who work in county councils, the lorries carrying waste within our estates or on our roads should ensure that the waste is covered properly so that it does not spill onto our roads or into our houses in transit. And you have a right to complain or report to your respective county government health authorities to ensure that this is corrected, because it is a health and safety hazard to the residents. So regulatory authorities such as NEMA have developed regulations that govern the disposition of waste or disposal of waste. Another source of this legal framework or laws is international standards, such as ILO conventions. As I mentioned earlier, conventions are agreements or treaties that were developed by ILO under the auspices of the United Nations. And for countries that have ratified these conventions, they are bound to implement them. There are quite a number of these conventions, like Convention number 87, Convention number 98, Convention number 101, 102, and 103. These are international standards that relate to the rights of employees, employment of minors, forced labor, and rights such as assembly, association, or picketing. So when we look at these international conventions, then we are able to develop policies that are aligned. The other source is court rulings. Our courts, under the Constitution 2010, are very powerful, especially the Labor Relations Court, that it does not only give interpretations of the law, but can also enforce compliance, especially when managers or organizations are violating the labor laws. For instance, unfair dismissal. If an employee has been dismissed on account of poor performance, probably the managers did not take the employee through a PIP and supported him or her. This employee can go to court and seek justice for unfair dismissal. And we have already case studies of organizations that have been compelled not only to reinstate the employees, but also to pay them the period in which they were out of work and other costs, including the cost of the legal suits. So the interpretations of the courts are very key, and we derive some of our legal frameworks. And you remember, the legal frameworks are not just about laws and regulations. They include policies and institutional arrangements. and that forms the framework. All of them work together. And lastly is industry guidelines. These are requirements which are set by certain players in an industry to govern them. For example, in the manufacturing industry, some organizations require their employees to report to work even on Saturday. So Saturday is a working day. That does not mean that they are violating any law. No. What they have set as a standard is that Saturday is a working day and people are paid the normal wages for that day. Others in the health sector, for example, hospitals, have their guidelines as well, depending on the type of employment contract. For doctors, some of them are on call 24 hours, that they can be called at any time of the day or night. For purposes of supporting them and motivating them, the specific organizations can give them disturbance allowance, travel allowance, or even risk allowance, because these are personnel who are exposed to many risks as they travel at night. Or when they are supposed to be with their families, they are called for an emergency. So those interruptions should be paid as benefits. On that note, I want to invite questions or comments related to what we have covered this afternoon, starting with the introduction, where we gave a definition of the legal compliance. 2, we talked about the legal framework as a structured system of all this, laws, regulations, policies, and institutional arrangements. And now we have just finished the scope of legal compliance. So anybody with a question or a comment, please go ahead. You can raise your hand. I can see you from wherever I am. You can also chat with me in case you may not be hearing me properly. Or you can say something. Somebody by the name Samsung. You can see your mic is on. Please go ahead with your question or comment. Charles Gitau, if you are there. Esther. Sarah. Yes, Sarah, go on.
Good afternoon.
Kindly increase your volume. I can't hear you.
I hope I'm now audible.
Yes, I can hear you. Go ahead.
All right, thank you. I wanted some clarity on this something you mentioned on the overtime payment. Yeah, so the organization I work for, we have we work 24/7. The kind of work we do, we have people working around the clock. So I wanted to ask about Sunday, because we have some people who work on Sundays and some don't. We have two kind of shifts. There are people that are working under shift, then the rest they work from Monday to Saturday. So the ones that work on Sunday, do we treat that as overtime or how do we treat that?
As I had mentioned, thank you, Sarah. As I had mentioned, a working day is defined by your policy. And any day of the week can be a rest day. If those people working on Sunday can be given a day off in a week, say Monday, Tuesday, or Wednesday, so Sunday becomes a working day. What the law provides is that an employee should be given one day off in the week for resting. And that day can be Sunday, Monday, Tuesday, or Saturday. Then you asked, there are some employees who work in shifts on Sunday, others don't work on Saturday. So your work week ends on Saturday. That means that those whose work ends on Saturday, they rest on Sunday. How about those who work on Tuesday? Perhaps you may need to clarify that. Are they given rest? If yes, then Sunday is their working day. However, if there is a gap in the sense that those working on Sunday do not have any other rest day, then you should make it a policy that working on a Sunday attracts overtime. If all work must end on Saturday, then Sunday becomes a rest day. And anybody working on a resting day should be paid overtime. So kindly review your policy on payment and policy on working time and align accordingly in respect to the Employment Act.
Yeah, thank you so much for that clarity.
Karibu sana. Anybody else? Charles, if you are there, please ask a question or make your comment. Benjamin? Esther? Administrator? Margaret? Okay. I will want us to move to the next slide and talk about challenges in legal framework review. That when you are auditing the legal framework, what challenges are you likely to face? Quite a number of them. One is the dynamic laws. By dynamic, we mean that they are in a continuous state of change. That the laws of yesterday are not the laws of today. And that depends on the legislations that are made by our parliament, or the gaps that exist in our respective industries where regulators come in to set those guidelines like NEMA. With this dynamism, we are expected to conduct our legal compliance audit on a regular basis. And doing so has several implications. One, cost implications. That conducting an audit on a regular basis, say monthly or quarterly, is expensive. And in some cases, we may not do it internally, but we can outsource this process to an expert outside in the form of a consultant. Two, the time constraints. That it is not easy to do a legal mapping with the many changes that take place in our legal environment. So it requires a lot of time to see which laws have changed, where have they changed, and which aspects of our systems, policies, and practices are affected. So it requires frequent changes in our policy and updating, which can be expensive and time consuming. But again, I'm comforted that those of us with the legal departments or research departments are able to capture any changes in our legal system and take the necessary actions to ensure compliance. I'm talking about the legal department or research department, which should always be on the lookout for some of these changes in our laws. But it's expensive, it is time consuming, and that is why it becomes a challenge. Secondly, is the interpretation of these laws. I am sure all of us have had lawyers argue in court, and most of them quote this phrase or clause. The law is very clear. Every lawyer standing up says the law is very clear. Then the question is, how come some of the lawyers lose their cases if the law is clear? If it's clear to one, it must be clear to everybody. That brings to mind the element of interpretation. The way you interpret an aspect of law is not the way somebody else can interpret it. So to me, the law is very clear because of my interpretation. And to any one of us, the law is very clear according to your interpretation. So in some cases, we do not have a clear interpretation of the laws as they are. Even for lawyers that have been in practice for long, they still have challenges of interpretation. That does not mean that the lawyers are wrong. It could also be a problem with the magistrate or judge. They can also misinterpret the law. So that makes it complicated. Perhaps that is why it was originally called the learned friends. Learned because they are supposed to be knowledgeable, thoroughly knowledgeable about the law. And it should be expected that they are knowledgeable. For people outside the legal profession like HR managers, it is even harder for us to interpret those laws. And therefore, it becomes a challenge, especially in the absence of a legal officer in our organizations. Thirdly, is resource constraints. There are three resources. I will talk about two. One is the financial resources, and two is the human resources. Speaking of financial resources, no organization in the world that I know of that has unlimited financial resources. Money is always a scarce resource. And being a scarce resource, it becomes harder to find or even access. How is it a challenge in the legal framework? One, we need to get an expert in legal matters to draft for us a policy, a legal expert. If not a legal expert, we need to get a consultant, and we have to pay this consultant. Some consultants are very expensive. Some legal experts are equally expensive. So in terms of financial resources to be allocated to the review, it is expensive. Secondly is the human resource, the personnel. Not everybody working in a HR department is knowledgeable about the law, particularly the labor laws. On very rare occasions, do we find a HR manager arguing out a case in a court of law, except through their legal officers or a lawyer they have contracted from outside. So organizations are limited in terms of skilled, experienced, and knowledgeable experts within the organization. So in the absence of these experts, the human resource becomes a constraint or a challenge. The other challenge is resistance. That when we review our laws, particularly our policies and institutional arrangements, which are part of this legal framework, they imply change. And when we change these policies, some employees or other stakeholders can resist. Resistance means refusal to accept change. And when they resist, there is little progress that is made, especially when it comes to implementation. Resistance can be shown in many ways. One, employees being absent on the day they are required. Two, others becoming late. Three, others refusing to cooperate. And four, others walking away or resigning because whatever is being changed is unacceptable to them. So resistance to change is a challenge to many of our organizations when it comes to compliance with the legal frameworks or auditing the legal framework. And then lastly, this exercise of reviewing the legal framework relies on documentation. Documents are important and we cannot do without them. Whether they are manual documents, call them physical, or electronic documents, this must be kept at all times. I may have mentioned the purpose for documenting, one for referencing, and two as evidence in case of a court case. In many courts, actually in all courts, the lawyers always ask for evidence, and even the courts, where is the evidence? And all courts are courts of evidence, that unless there is evidence, everything else is a rumor. And the courts don't work on rumors. I want to give an example of termination of a contract on account of poor performance. Some organizations take their employees through a PIP after failing to meet the targets and then after the PIP, they terminate their contracts. These employees go to court and sue their employers for unfair dismissal. I'm sure we are aware of such cases where employees are reinstated and paid their dues because the organization did not ensure that they have supported the employee. Any support that we give the employee during PIP must be documented. If it is an extra person who is allocated to assist that employee, must be documented. If it is a tool or an equipment given to the employee, must be documented. If it is performance levels of the employee during PIP, must be documented. If it is a mentor or a coach given to the employee during PIP, must be documented. So documentation is required through and through in all our activities. And these documents can either be physical or electronic. Specifically related to legal framework, our policies must be documented. Our rules and regulations must be documented. Our codes of conduct must be documented. There should be nothing verbal. Even a formal oral warning, I emphasize that, must be documented. Otherwise, when somebody goes to court, the court will ask for evidence. And if you don't have evidence of an oral formal warning, then that becomes a witch hunt. And the employee might easily win the case. So those are some of the challenges facing HR managers when they are auditing the legal framework. What are the laws or the labor laws which are the focus of HR auditors? I've given about 8 of them, starting with the first one here, that is the Employment Act. Among other things, this Employment Act regulates contracts, leaves, termination of contracts, and employee treatment. I've talked about contracts, which can be permanent and pensionable, fixed term, or short term. And the auditor under this Employment Act should review all the contracts. Are they working? If they are not working, what needs to be done so that corrective action can be made in compliance with the law? Secondly is leave. All of us are entitled to 2 types of leaves. One, annual leave, and 2, maternity or paternity leave. These other leaves are a matter of policy, like sick leave. There is no law in Kenya which says that you must be given a sick leave of 2 weeks or 3 weeks. So your policies, which is part of this regulatory and legal framework, should provide the leave days or the types of leaves outside the 2 that I have given. Other types of leaves include study leave. Some organizations give their employees an opportunity to go and learn outside the country, so they go for study leave. Others go for compassionate leave. Others go for adoption leave, where they are adopting children. So these leaves are provided for under the Employment Act. Termination is about ending of a contract. There are two ways of terminating a contract. One, voluntary termination, such as early retirement or resignation. Or it can be involuntary retirement, which is a must, or forceful, which is dismissal as a form of termination, or attainment of the mandatory retirement age. Or in some cases, it can be through mutual agreement, especially when an organization does not have work to do and both the employer and the employee mutually agree to terminate the contract. Those terminations under the operation of law are like retirement, attainment of the mandatory retirement age. Then fair treatment of employees, that all of us have a right to be treated fairly. As I mentioned earlier, fair treatment also includes non-discrimination. Employees should not be discriminated against. Secondly, another labor law is the Labor Relations Act. This act focuses on or regulates union rights, CBAs, that is collective bargaining agreements, among others, or dispute resolution mechanisms. A dispute relates to a difference between employers and employees. But if it's individual employees and individual managers, those are complaints and you can call them grievances. But disputes touch on the whole organization. Those disputes that arise between the employees and employers are catered for under the Labor Relations Act. There is a sister act which is called the Labor Institutions Act, where the trade unions, the Labor Relations Court, and the work councils are mentioned and their roles. This is something that we need to check out. But what is most important to us under the Labor Relations Act is the rights of trade unions, signing of CBAs, and dispute resolution. We should therefore have an understanding of this Labor Relations Act. I am quickly reminded of some of us who are specialists in particular areas of HR, and that is either industrial relations or employee relations. If this is your area of specialization, then this must be your cup of tea. You enjoy it. You enjoy negotiations with trade unions. You enjoy settling disputes. And in cases where disputes cannot be settled in the organization, they can be taken to the labor office for intervention or for arbitration. If not, then people can approach the Labor Relations Court, which is provided for under the Labor Institutions Act, so that your case is addressed. Occupational Safety and Health Act talks about inspections of workplaces for safety and health issues. Safety are issues that are likely to cause harm or injury to people or company property. So Health and Safety Act provides all those regulations, such as spaces in the workstations, ventilations, general cleanliness, provision of clean, safe drinking water, and also separate ablution blocks. And then within this act, there are inspections that are done by the health and safety committees, which is a requirement by the OSHA. Every organization must have a health and safety committee, which not only does the inspections, but also listens to complaints about health and safety situations in the organization. The other law is Work Injury Benefits Act. That this is an act specifically addressing injuries in workplaces, not only within the organization, but even outside the organization when an employee is directly involved in work-related activities. For example, a driver who is sent to deliver luggage outside the office, when on the road is still in the office. And anything that happens to him or her on that road is a work injury. And he or she is entitled to compensation. But if they deviate from the route, then that becomes another issue, which should be a subject of investigation. And if found guilty, that officer may be disciplined. And then another law is the Labor Institutions Act, which audits wage orders, inspections, and all other standards that are set related to the institutions. NSSF Act, I should revise this. Now SHA, revised. You look at the word revised, it's now SHA. But on NSSF, this is about the registration of employees, especially for employers who have more than 5 employees, remittance of contributions, and timely remittance for retirement savings. Deduction of contributions and remittance. Maybe some of us have fallen victim of non-remittance of contributions. That is an offense, and if found guilty, you can be fined heavily. As a requirement, therefore, you are required to verify registration as an organization with NSSF and registering of your employees with NSSF, deducting their contributions at source, and also presenting their remittances to NSSF. Failure to do this, you will attract lawsuits, penalties, as well as fines, because it's a legal requirement. Now talk of SHA. It talks about registration just like the former NHIF, deduction of remittances, and also ensuring health cover. I am aware of the many requirements for registration and remittances, especially remittances. If you do not remit SHA deductions on time, there is a penalty. Or if you don't remit in full, in case one of your employees is injured or is sick, you have to provide evidence that they are a part of the remittances that you send. If they are not, then they will not be covered. So this becomes a very serious issue, especially now we are talking about penalties for late remittance and also failure to be covered if the money that is remitted does not cover all the employees. So we should comply with all these regulations to be on the safe side. And lastly is the Employment and Labor Relations Court, specifically designed to handle matters related to labor relations, such as dispute handling, compliance with rulings, and settlements. Disputes, as it were, relate to differences between employers and employees. It could be individual employees or their trade union. I'm sure we are all aware that our lecturers in public universities were on strike. They had a dispute with their employers, which are the universities. What were they complaining about is non-compliance with the collective bargaining agreement of 2018 or 2017 or thereby, which have not been implemented fully. And now they are being invited to another cycle of negotiations even before the previous CBA has been implemented. So the Labor Relations Court comes in to review and settle such kinds of disputes. The court is an arbitrator or can assign somebody else to bring these people together to work on certain issues that are contentious. Or the court can give both parties a period of time, say 1 week, within which they have to meet and come up with an agreement. And whatever agreement they come up with is registered with the court and becomes binding. And then the court also enforces compliance rulings that anybody who does not comply with this ruling is in breach of court orders, and that is a violation of the law. In law, that was they call contempt of court, that you have disobeyed court orders. And such disobedience may lead to further actions, including sanctions. For example, you can be sanctioned not to appear in that court unless you have complied with certain requirements. So that becomes a disadvantage for the organization because you have been sanctioned and certain things may not move because there is a ruling that you have to adhere to. Then settlements, these are any awards that are given to either employees or employers after hearing their cases, or any agreements that are reached as a result of the court process. So, ladies and gentlemen, these are some of the labor laws that regulate or govern the employment relationship. Before we take another break, I want us to look at the benefits of legal framework in HR audit. One, like I mentioned earlier, it reduces the risk of lawsuits, which is time consuming. It reduces the risk of fines and also reduces the risk of penalties. I think to that end, all of us are clear. Secondly, it enhances organizational reputation and employer brand. This refers to the image. If you are an organization that is compliant, then you build for yourself an image that potential employers, potential customers, and potential investors may be ready, willing, and available to work for you or with you. When you have such a reputation, you are likely also to attract new employees because you comply with the legal framework, and employees are assured to be treated fairly and justly when they join the organization. Thirdly, it promotes or ensures fair treatment of all employees. As you may realize, most of the employment or labor legislations work for the employee. Though I am aware, especially the Employment Act, Work Injuries Benefit Act, there are responsibilities of the employers. The employees are the most affected, and therefore compliance with the legal requirements ensures fair treatment of all employees. Another benefit is that it ensures or aligns HR practices with local and international standards. The local standards are the legal and the regulatory requirements. International standards are the conventions like ILOs, which help us to ensure that our policies, our practices, and our systems are working efficiently and effectively. And lastly, an audit of the legal framework helps to promote ethical business practices. We are all bound by our professional ethics. Such ethics touch on aspects like 1, integrity, 2, professionalism, 3, confidentiality, 4, adherence to the law, and 5, fairness. So these ethical practices should be reflected in all our functions, starting with recruitment, ethical, training, ethical, performance management, ethical, compensation and rewards, ethical. So those ethical standards should always be promoted. And our laws are forms of ethical standards, which, if practiced effectively, they should ensure fairness and also avoid those lawsuits and penalties. So I would like to again ask you to ask your questions, make your comments, and also any compliments you can mention. So 1, challenges. 2, labor laws. And 3, benefits of this legal review, framework review. Any question? Anybody with a question or a comment? Please go ahead. Margaret Irungu, if you are there, please ask a question or a comment.
Thank you. I am okay for now.
Well, thank you, Margaret. I'm happy you are okay, and that we are addressing issues that are relevant to you as an individual and as an organization. Esther? Lillian? Frida, the last one. Frida, if you are there, please ask a question or make your comment. Okay, go ahead. Okay. Let us now move to the next part, which is the second part of this presentation. Remember, we were talking about three parts. One, legal framework. Two, compliance mapping. And three, disciplinary procedure. We are on the second one, which is compliance mapping. We have talked about legal compliance in the first part. And now we want to map that compliance with our policies, our practices, and our systems. By mapping, we mean linking those practices, those policies to the legal and policy framework or requirements. There must be a linkage. For example, we go back here to the various laws. For example, NSSF Act. In auditing, we must verify registration. We must deduct contributions and then remit. So when we are doing mapping, we are looking at our policies on retirement, including NSSF. Do we have a policy that governs that area? That is one linkage. If the policy exists, are the legal requirements being implemented? If not, that becomes a gap. And then from there, we can make a proposal or a recommendation to fill that legal gap. And in this section, I'm going to show you a template that shows how we can map two of our functions like recruitment and training or recruitment and compensation, and show the gaps, the legal gaps, and what needs to be done. Secondly, what's the purpose of mapping? Is to establish where and how compliance is being achieved, or in some cases, not achieved. It's always good to be positive so that we focus on areas where it is being achieved. The scope, what does mapping cover? It covers all the aspects of legal framework. I mentioned some of them, the law, the policies, the regulations, and lastly, institutional arrangements. So specifically, it covers the employment law, which we have said, some of which we have covered, 8 of them. Secondly, it covers safety, because safety is key. Thirdly, it covers equity, matters fairness, that employees should be fairly treated. Otherwise, if not, then that becomes discrimination. And lastly, international code of conduct or codes. This must be reflected in our policies and practices. Then processes or the process of mapping involves one, identifying relevant areas, that means mapping. Two, identifying gaps. Three, developing action plans, and I will show this. And lastly, documenting this. Because as I mentioned earlier, one of the challenges of legal compliance is documentation. It is heavy on documentation. But don't be tired, because when you document everything, you are safe. Then what are the tools that we can use for mapping? We can use spreadsheets, such as Excel. Some of us use Excel a lot to do this mapping. Others use matrices, like the one that I have is a matrix. Others use dashboards. These are electronic systems or digital tools where compliance officers, HR managers, or any other employee can post their audits or identify those gaps, and the relevant authorities can pick them from here. A dashboard. This allows real-time sharing of information or knowledge that once a person has posted on this dashboard, anybody who has rights can access this information. That is the beauty of technology, that it allows us to do things in real time as they are happening. And others can use audit software. I am aware of some organizations that have systems that have all the legal requirements. And if there is any gap, it is able to pick it out and send it to the relevant authorities, especially the use of modern AI, artificial intelligence, which can pick all the legal requirements, map it with our practices and policies, and identify gaps where there is non-compliance. What is the end result or outcome of this mapping? Is that we are able to have a clear view of compliance health. As I mentioned early in the morning, HR audit is a form of diagnosis. It is a health check. And this health check, particularly with compliance, we are looking at the legal compliance. How healthy are we? If we are not healthy, it means that there are many gaps of non-compliance, and that poses risks to our organization. Just like diseases pose risks to an individual. So the earlier we diagnose these health issues, the better for us. What are the key elements of mapping? I have mentioned 5 or 6. 1, policies. So we look at our policies against the law. Do these policies cover all the legal provisions under the law? If we find that there are gaps, then we are able to flag them out. Secondly is regulations. It could be our own code of regulations or industry regulations. And as I mentioned, we can always check out on regulations that are set by various regulatory bodies, such as NEMA, or within our own regulator, that is IHRM, is a regulator. So there are regulations that govern the HR profession. And then another element is control. What mechanisms do we have in place to ensure that there are no excesses or there are no violations? These are in terms of procedures that ensure that these policies, these procedures, and the processes are properly implemented. Another element of compliance is evidence. This is documentation. We cannot run away from documenting our policies, our procedures, and processes. If we document everything, then we are better off. That in case we want to make reference to any issue, we have a document. In case there are any complaints, there is a document to show evidence. So those records are important, and please keep them properly in accessible repositories, which could be in form of systems like record management, document management systems, or records management system. Document or record management system. Or you can put them in a database where all the records of the company are kept for purposes of having evidence. These are repositories. And then ownership. When we do mapping, we want to ensure that there is a person who is responsible for the actions recommended. It is not okay to do the mapping by way of identifying the area and the gaps, and then we don't have a person within the department or elsewhere to ensure that the actions are being implemented. So ownership is key because we know who is to be responsible for what. And then lastly, risk level. What is the level of risk for non-compliance? We have mentioned several risks like legal risks, financial risks, or reputational risks. When we evaluate these risks in terms of impact, we should be able to tell which of these risks, either legal, financial, or reputational, has the greatest impact, and map that against the potential or likelihood of happening. So when we look at impact and the likelihood of happening, we should be able to identify which of those areas we should give priority. So in terms of prioritization, it depends on the level of impact and also the likelihood of the risk happening. If the impact is high and the likelihood is high, you give that risk first priority because the impact is high and the likelihood is high. So there's no waiting time, you prioritize. What is the purpose of compliance mapping? As I said, mapping is about detecting gaps that exist between our policies and practices and the law or regulations. When we detect those gaps, Then, one, we are able to identify risks. And we know which of our laws that are being violated and which risks are likely to happen if we do not comply. I repeat the risks. One, legal risks or lawsuits. Two, financial risks. And three, reputational risks. When we do a mapping between the policy, and that is what is happening in our organization against the law, legal requirements, we are able to identify those gaps which pose risks. Number two, we are able to standardize our operations and practices. How is this done? For example, the law requires that employees should not be discriminated against. Then our policies that we develop diversity policies, that everybody has a right to be employed, to be promoted, to be rewarded, or to be trained. That harmonization is important for our organizations. Why? Because we reduce grievances and disputes because of non-compliance. For instance, an employee can protest against a final selection if she feels that she was or they were discriminated against during selection. And if you are an equal opportunity employer, you should give everybody an equal chance to be promoted or to be hired. So that equal opportunity is a standard practice for organizations. The other purpose is efficiency. Efficiency has to do with three things. One is ensuring that our practices, our policies are not costly, the element of cost. Because if we don't comply, then we'll run the risk of penalties, lawsuits, and fines, which is a cost to the organization. An organization that is compliant will avoid those costs related to violation of the legal requirements. Secondly, in terms of efficiency, we are avoiding duplications. Where we have two or more policies that are duplicated, we can develop one policy to cover aspects related to work injuries or occupational health and safety, instead of having all of them separately, which becomes redundant. So by mapping, we eliminate those redundant policies or those duplications in our systems. Then another purpose is accountability, that there is somebody who is responsible for compliance. In our organizations, there are three groups that are responsible for compliance. One is the HR manager. You must comply with the law when it comes to recruitment, training, performance management, and rewards. You remember we talked about minimum wages. If there is an employee who is paid below the minimum wage, you are responsible. Secondly is the legal officer. This is the advisor of the organization, both to the HR manager and also to the top management. The legal officer gives his legal opinion or advice when it comes to matters compliance. For example, employees have been terminated on account of redundancy. The first advice is that by the counsel or by the lawyer is that the organization must report the nearest labor office of the intentions to declare some people redundant. And then advise them on the criteria for redundancy. And then advise them on their terminal dues, including terminal benefits for terminating the contract prematurely, which is 15 days for every working year. Then their pending leave days. If there is any gratuity, they should be paid. And if there is any claims, such as unpaid salaries, should be cleared. And this can be done either in one tranche or can be done in phases, depending on whether or not the organization can afford the amount for redundancy. So due process must be followed, and the second person responsible is the legal officer. The last person who can be held responsible is the internal auditor. Internal auditors are meant or must ensure compliance. And that is why we have that annual cycle of internal audit to identify where there are gaps. So when you are doing your compliance mapping, please ensure that you have identified the person responsible for the actions intended, either the HR officer, the legal officer, or the internal auditor. Compliance helps us to make improvements. Improvements in our policy, improvements in our practices, and improvements in our systems. For example, you have a system like ATS, Automated Tracking System, which helps you to avoid discrimination when it comes to shortlisting. So if there was discrimination before, then you automate as a recommendation coming out of compliance mapping, then that becomes an improvement. And there are other forms of or areas of improvement that we can make. For example, compensation. Our Excel sheets or spreadsheet should be able to pick out an employee whose payment is below the minimum wage and send a message to the HR officer or to the finance people before they print or post the final payroll, so as to be sure that there is nobody who earns below the minimum requirement. So after compliance mapping, you may find that there are people who are earning below the minimum wage, and then you recommend a system like a spreadsheet, which will pick out those cases which are violated, and that becomes an improvement. What are the key areas of compliance? Because we're talking about compliance mapping. One is the employment practices, including recruitment. If you look at the Employment Act, matters recruitment relate to discrimination and contract. Compensation also relates to recruitment and selection, particularly with the contract. And then promotion. So recruitment, compensation, and promotion should be adhering to the labor laws. Those areas are compliance areas. Secondly is health and safety. There are many compliance issues like safety, like health and safety committees or inspections of workplaces. This should meet the minimum legal requirements according to the two acts. One, Occupational Safety and Health Act, and two, Work Injuries and Benefits Act. So health and safety is covered, is an area covered under the law. Data privacy is covered under the Data Protection Act, which I mentioned, talking about privacy and confidentiality of data and information. Personal data is protected under the Act, and the personal data include the phone numbers, the postal addresses, residences, that is personal information. Private information relate to marital status or number of children and others. This information is protected. Another area is harassment. Many of our policies have a harassment policy. You must clearly define what harassment is, what are the forms of harassment, and how this can be enforced. We know for a fact that harassment can lead to grievances, disputes, or even employee exits. We might lose a good employee because of this harassment. The most common form of harassment is sexual harassment, both by male and female employees. So your policy must come out clearly to ensure that nobody is harassed, either by way of communication through phone or text, or by way of touching or other forms of harassment. And then another area is the environment in which we operate. This environment must be healthy and safe. This is because we want to protect our employees from injuries or from illnesses. Allow me to repeat that a healthy and a safe workforce is a productive workforce. So for that reason, all aspects relating to the environment must be protected. Under the Work Injuries and Benefits Act, we must ensure that all hoists, machines, and lifts must be maintained on a regular basis. It is a legal requirement. Under the OSHA Act, OSH Act, inspections must be done by the Health and Safety Committee. It is a legal requirement to ensure that the environment in which we operate is healthy and safe. So when we do compliance mapping, these are the areas where we look at. Are these areas compliant with the law? Before we take another break, we look at process of compliance mapping. That on the one hand, you have the laws and regulations. On the other hand, you have the practices. For example, the ones I've mentioned on bullet 1 up there, employment practices. So you want to map the two. Where do you start? You start with identification. And what are you identifying here? Two things. One, the existing laws, and two, the existing practices. Existing laws and existing practices. So you look at, for example, the Employment Act. What does it say in relation to the practices? And then two, you look at the existing practices. You identify them. So the two must go together. Secondly, you do an assessment. This assessment is done by comparing the applicable law and the existing practices. What do we want to identify? We want to identify compliance or conformity with the legal requirement. So we must tick the boxes. The law against the practices. So what is there a law? Yes. Is there a practice? Yes or no? Where there is an X, then that becomes an area of non-compliance. So that becomes your assessment with regard to conformity or compliance. The next step, which is step 3, you document which practices are not compliant and which laws have been violated. You develop or create a record. So once you have done all that, you identify those gaps, then you must develop action plans. These action plans are meant to bridge the gaps. For example, in recruitment and selection, a policy may exist, but this policy does not talk about discrimination. So what recommendation can we recommend for implementation? It is a review of the recruitment and selection policy, particularly on discrimination. So when it comes to implementation, we recommend that we review that policy. Then who will review it? The HR manager. When will it be reviewed? In the second or third quarter of 2025. What are the resources required? HR policy and the employment or labor law. the relevant one. And then what are the timelines? We should be able to establish that. Once the recommendations have been implemented, then we review periodically. Periodically can be either quarterly or biannually or annually, depending on the need. But again, I say, for purposes of continuous improvement, the legal department, as well as the research department, should continuously review changes in the labor laws and update them so that we do not firefight when it is too late. So that is the process of compliance mapping. Lastly, who are these people responsible for compliance mapping and implementation? One is the HR department. For those of us who are HR officers, we are responsible for overseeing all compliance issues related to policies, related to practices, related to systems and procedures. The legal team, their work is to provide advice to the HR manager and also to the top management, and also interpret the laws correctly. Managers in other departments, they should ensure that all the labor laws are followed. And if not, they should notify the HR manager and the legal team so that action can be taken. And then what's the responsibility of employees? Employees are usually at the receiving end, and their work is to operationalize the policies, the procedures, and the systems. And what does that mean? They must follow or comply with all the policies, with all the regulations as set out by the department. And lastly, the internal auditors or even external. Their responsibility is to conduct independent reviews. But how independent they are depends on your organizational politics. In some cases, for purposes of compliance, there is always interference from some quarters. You are told, don't report that one, so that you can protect yourself. But again, you can only hide. But for how long can you hide? The law will always come for you. So the auditors provide independent reviews. As an HR auditor, you have a role to play specifically in relation to compliance. One is monitoring. Monitor all the HR practices, policies, and systems against the legal requirements or frameworks. The legal frameworks, as I mentioned, if I may repeat: one, the law; two, the policies; three, regulations; four, industry standards; and five, international codes of conduct. So you must always be monitoring. If there are any changes in this, please pick them out, review your policies, and ensure compliance. Secondly is advising. We may have all heard of complaints from managers that they are told by the authorities to dismiss a person or not to pay a person without following due process. Please advise them accordingly. Let the due process be followed. Your advice is very important because you are a professional and you are an expert in this area. Training, please educate your staff on compliance matters. As HCHRP, we have conducted several trainings related to the Data Protection Act. And I'm sure some of us have attended such trainings. So as HR auditors, please send your employees for training for compliance so that you do not have issues related to compliance because employees do not understand those laws, or two, they don't know how to implement them. So training helps people to acquire skills and knowledge on compliance. Another compliance role is reporting. As HR managers, we report to higher authorities, especially the board. We provide evidence on our findings related to compliance. So when we are reporting, especially in matters compliance, please ensure that you capture, one, the areas of audit, two, the legal requirements, three, the gaps, non-compliance, four, the risks involved, and then the actions required. When you are reporting, those are the things that should be contained in your report. And then another role is to update all the HR policies and practices on a regular basis. Updating. This can be done as a team, especially with the assistance of the legal team, the research team, and the internal audit. Once they have identified changes in the legal environment, they can advise you on those changes, and your role is to update your policies to accommodate those changes. And that is why we should ensure that we review our policies from time to time, one, to update them, and two, to ensure compliance. Lastly is follow-up. It's about monitoring progress and identifying areas of non-compliance. Once we do that, we will go back to the cycle of process of mapping, which we have just covered up there. If I may go back there. Identification, assessment, and review. You look at the last bullet there, number 5, review. This review is the last one there, which means you follow up, identify non-compliance, and then you start the process again. I promised to project a template showing how we can do compliance mapping. And as you can see, there are several columns and rows. Those columns show area, for example, recruitment and selection. Then the legal requirement, especially in terms of contracts. All employees must have a written contract. Written, underline written, because it's about documentation. Then what is the source of this legal requirement is the Employment Act. What is the current practice? As you can see, contracts are issued only for permanent staff. And that shows a gap that other staff are not given contracts. Compliance status, because it's only complying with one area, we can say it is partially compliant. And what is the gap? It is lack of formal contracts or casual statements. Casuals are not given contracts or lack of formal contracts. And then a recommendation on what should be done. So you can do this for all the areas of HR, like performance management, disciplinary procedure, or other aspects like training. So this is a template that you can have when you are doing your compliance mapping. The beauty of this is that we shall post these notes on our website, and you can access them at any time upon completion of this training, upon completion. The last aspect for today is audit of disciplinary procedure. Disciplinary is an action, and this action is a corrective process or procedure where employees have committed offenses. The opposite of discipline is indiscipline. So disciplinary procedures are taken against employees who are indisciplined. And indisciplined employees are those who have violated the policies and the code of conduct of the organization. Because this is a pertinent issue, that is why we have given it prominence out of the many employee relations issues. So we want to audit this procedure because it is one of the gray areas that gives many people headaches. By auditing this process, you are able to avoid those unnecessary lawsuits, which are very common in many of our organizations. What is the objective of this audit? One is to ensure fairness, that the actions we take are impartial, transparent, and non-discriminatory. Two, to check compliance. Compliance with which law? The Employment Act in particular, which talks about disciplinary process. And the Employment Act stipulates the various offenses that employees can commit, categorized into two: one, minor offenses, and two, gross misconduct. And the procedure is given. In case of a minor offense, a warning or a reprimand can be given. But if it is cumulative, meaning that minor offenses are repeated, they become gross misconduct. And the Employment Act provides the procedure for handling such indiscipline. That's why we talk of disciplinary procedure. The due process must be followed. For example, if a gross misconduct has been committed, one, this offense must be recorded immediately it is committed. Two, in some cases, it is investigated. If not, and because you fear that the employee might interfere with evidence, a suspension is given pending investigation. Then show cause can be written. Employees can explain themselves, and then a disciplinary committee is constituted and through the chair, a decision is made to dismiss the employee if found guilty. So compliance is very important in this process. Secondly, the objective of this procedure is evaluate consistency. Do the procedure rules apply to everybody? Or there are some sacred cows to whom these rules don't apply? The sacred cows are those people who have tall relatives. They are untouchable. And sometimes we are in a dilemma when the employee in question is a relative of the MD. That becomes very tricky. Then another objective is to protect the rights of employee, especially when it comes to disciplinary. All employees have a right to be heard, and this is on the fact that, or on the premise that, everybody is treated not guilty until proven guilty. And that is why we cannot dismiss an employee before hearing him or her, because they may not be guilty as we may have perceived. And lastly, this process helps to support organizational culture. Culture consists of three things, like I mentioned in the morning. 1, values. 2, norms. 3, beliefs. Speaking of values, we are talking of values like accountability and professionalism. That all employees are held accountable for their actions in this disciplinary process. And professionalism, that we are there to all the processes and also ensure confidentiality in this disciplinary process. What are the areas of focus in a disciplinary procedure audit? 1, existence of a policy. Is there a policy on disciplinary procedure or in discipline? It must be clear and written. 2, is there a communication policy that in case somebody has committed an offense, is there a channel of communication? 3, fairness and consistency, which we have mentioned as a benefit. You look at the benefits here. Bullet 3, as an objective, evaluates consistency. So when we are applying this disciplinary process, we look at fairness and consistency. Does it apply equally to everybody? Due process, needless to emphasize, when you don't follow due process, then that becomes a compliance issue, that we are not complying with the Employment Act on matters discipline. Then documentation, we must document everything. And as I mentioned, even an oral formal warning should be documented. And lastly, corrective versus punitive actions. Corrective actions is that we want the employee to improve. Punishment is to make employees feel pain and also to prevent others from committing such an offense. So we can apply both, but the emphasis should be on correction. But for gross misconduct, if found guilty, there is no room for correction. It becomes a punishment, they have to go. And that becomes a factor that can prevent other employees from committing the same offense. Audit criteria, I can mention this few. 1, due process must be followed. All audit checks must be done to ensure that we comply with the disciplinary compliance audit or disciplinary procedure audit, due process. 2, you audit proportionality. Are actions taken commensurate with the offense? Once upon a time, Professor Lumumba said that you do not respond to a mosquito bite using a sledgehammer. That bite is a small one, and if there is a minor offense, you don't come down with a sledgehammer, such as dismissal. A warning can do for a minor offense. Proportionality. 3, timeliness. Do not wait until it is too late for you to take action. If somebody has committed an offense, take action immediately. However, allow enough time for cooling. For instance, 2 employees are fighting. You find them fighting. You separate them. And the immediate action you take is to call them to your office to explain. That anger in them has not settled. So it is prudent for you to give them enough time to cooling. But for other disciplinary offenses, like theft, there is no room for cooling. You take immediate action. Then consistency, which I've said that disciplinary actions must be consistent throughout. It doesn't matter who has committed the offense. That's the only way we can ensure fairness. Integrity, ensure that all disciplinary action reflect the integrity of the organization. That means that any action must be based on data. We must take action based on data, which means that all records must be kept and can be traced within our system. Lastly is legal alignment. Does the disciplinary audit align with the law, particularly the Employment Act? Our third last slide for today are the challenges facing disciplinary procedure. One is bias because of our own personal experience or our own personal feelings about the employee. Experience about your interaction with the employee, you thought that they are bad employees, or they committed an offense once and therefore they are perpetual violators. 2, resistance. People can resist any verdicts or decisions made after the disciplinary process. 3, incomplete records, just like we mentioned as a challenge in regulatory compliance. Legal complexity, there are many laws that apply when it comes to disciplinary. And then lastly, confidentiality concerns where sensitive information is shared with those that were not in the disciplinary panel. We must monitor outcomes of disciplinary audits. 1, we identify a trend so that we identify those common disciplinary cases and take mitigation measures. 2, we get employee feedback on the fairness of the process that has been applied. 3, we review past cases to ensure that we learn from our past mistakes or even successes. 4, we must always revisit our policies to ensure that the policies are updated so that we are not dealing with cases that are not covered in policy. And lastly, management reporting. When you have done a disciplinary audit, please share that report with the relevant authorities so that we remain accountable. So those are the areas that we were meant to cover this afternoon on legal and regulatory compliance. We looked at 3 key areas. 1, regulatory framework. 2, we looked at compliance mapping. And lastly, we looked at auditing disciplinary procedure. So I want to invite questions and comments related to what we have covered this afternoon so that we can bring this program to a close. So ladies and gentlemen, the floor is ours. Those are the areas that we covered today. And the topic this afternoon was legal and regulatory compliance. Any question related to the 3 key themes? Administrator, your mic is on. If you can be the first one to ask the question, please go ahead.
Sir, help me understand. You have said, how long will this course take?
This course takes 3 days, starting today until Friday. So Friday afternoon, we should be closing the training and you will get your certificate.
Thank you, sir.
You're welcome. Benjamin Kisang, I heard your voice in the morning. Please ask a question if you have any or make a comment.
Malima, actually, I don't have a question, but I still have to check the compliance mapping. I didn't get it very well, but as we continue with the course up to Friday, I will come back with some of the areas that you need to give me more clarification. On the area of audit of disciplinary procedures, how often can this be done? Is it are we supposed to do it?
Okay. 2 things. 1, we can do it as often as we can, depending on the policy that we will develop related to the HR audit. We are going to make HR audit as part of the audit cycle. So we can do it annually or biannually, depending on the policy that we are likely to develop. Secondly, on audit alone, audit of disciplinary procedure, because this is a procedure that is undertaken now and then. I'm sure in a week or in a month, many of us attend those disciplinary meetings. At the end of every meeting, it is advisable for the chair and his or her team to sit and have a look at how they conducted the process, what were the challenges, what were the strengths and weaknesses, so that next time when they convene another disciplinary meeting, they already have an idea of where they did very well and what needs to be done for purposes of correction. So speaking of disciplinary procedures on its own, you can audit it as soon as you have finished one process, so that as you go to the next, you are able to correct your mistakes, because employees usually go to court if they are not satisfied or if they cannot appeal to higher authorities. They go to court and they will identify certain gaps. And based on that lawsuit, you can always go back and say, yes, this is where we went wrong in this procedure, and the next time we should tighten on that area so that we don't have a repeat of what has happened. Benjamin?
Well said, Mwalimu, but outside this discussion, I'm sorry to take you back, in this the same disciplinary procedures. I
Yes.
don't know whether you've interacted in an organization where the union, there is the unionized employees and the management. When it comes to disciplinary of one of their members.
Yes.
The question which has been which we've been disturbing us here is: do the union, do the members of the union, are they required to be in the panel during the decision making? Okay, after the hearing proceedings, and then now it's the time to deliberate on the decisions. Are they allowed to be part and parcel of the decision making?
One, they cannot be the prosecutor as well as the decision makers at the same time. If they are on the side of the prosecution, they are prosecuting a case on behalf of their clients, they cannot again turn to be the judges on the decisions that will be made on their clients. Yes, it's a right of any employee to be accompanied by a representative or a witness. This witness can be an officer from the union, or a representative, or a fellow employee, or in some cases, a lawyer. In the case of a lawyer, the lawyer can only advise the client on which questions to answer and which ones not, but cannot engage directly. In the case of making decisions, the best practice is that it is the managers who will make a decision and not the union representatives, because the union represent the employees and therefore they cannot be present during decision making. Once they have participated in this procedure, I think their work is done. They should not come back and sit again in the panel or in the committee to make a decision against their own employee. That's my take. Benjamin?
Agreed, Mwalimu. Thanks.
Thank you very much. If there is no further question or comment, I want us to stop there for today. Thank you very much for your participation once again. I look forward to seeing you again tomorrow in the morning at 9. I want to wish you a good evening and God bless you all. Thank you.